Officer Derek Harlan had not the slightest clue that the woman he was about to handcuff had spent years on the federal bench presiding over cases involving police misconduct, civil rights violations, and Fourth Amendment abuses. The woman standing beside the black Mercedes remained utterly calm. She was not panicking, not crying, and not pleading at all. She was Judge Vivian Langford, and she had sent corrupt police officers to prison. She had issued rulings in qualified immunity cases. She had written legal opinions that became binding precedents in 3 states, and now she stood on the verge of becoming the plaintiff in a lawsuit that would cost the city hundreds of thousands of dollars and end multiple careers. Before we plunge into this absolutely shocking story, I need you to do something. Leave a comment right now and tell me where you are watching from, your country, your state, wherever you happen to be. And if you believe in holding figures of authority accountable when they abuse their power, hit that subscribe button. This story only grows more intense from here. You will not want to miss what happens next. Judge Vivian Langford was never someone who expected special treatment. She had served as a federal judge for years. She had handled death penalty cases, organized crime prosecutions, and complex civil rights litigation. She was fair, meticulous, and known for demanding the highest standards from both prosecutors and defense attorneys. That Saturday afternoon, Judge Langford had been shopping. Nothing unusual, nothing suspicious, just a typical weekend routine. She had gone to an upscale outdoor mall in La Jolla. She had bought a few household items and was loading the shopping bags into the trunk of her Mercedes when everything went wrong. The car was hers, properly registered, with current plates. She held the remote in her hand. She wore casual weekend clothes, jeans and a blazer, nothing flashy. She was doing exactly what thousands of people do every day in parking lots across America, loading purchases into a vehicle and preparing to leave. Then she heard the voice behind her. "Ma'am, step away from the vehicle." Judge Langford turned. An officer from the San Diego Police Department approached her with his hand resting on his service weapon, not drawn, but ready. It was a position of alert. Officer Derek Harlan responded to what he believed was a suspicious person call. Someone had reported a woman acting suspiciously near expensive vehicles in the parking lot. The description was vague. A black woman of medium build near a black Mercedes. That was all. No description of suspicious behavior, no report of any attempted theft, just a black woman near a luxury car. Officer Harlan had decided that Judge Langford was the suspicious person. She kept her hands visible, one still holding the remote. "Is there a problem, officer?" "I need you to step away from the vehicle and show me some identification." Judge Langford's legal mind immediately recognized what was happening. This was a detention under the Fourth Amendment. Officer Harlan had stopped her without reasonable suspicion of criminal activity. She had 2 choices: comply and fix it later, or assert her rights immediately. She chose to assert them officially. "I am loading my own car with my own purchases. I have the remote right here. What reasonable suspicion do you have that I am involved in criminal activity?" Officer Harlan did not like the question. Most people he stopped simply complied without asking. "Ma'am, I am investigating a suspicious person report. I need to see your identification." "What specific suspicious behavior was reported?" Judge Langford asked. "Because loading shopping bags into a car is not suspicious. It is normal. Someone called in a report." "A report of what specifically? What crime do you believe was being committed?" The officer's hand tightened on his weapon. "Ma'am, you need to cooperate." "I am cooperating. I am asking you to articulate the legal basis for this stop. That is not obstruction. It is my constitutional right." The confrontation was escalating. Other shoppers began to notice. Some slowed down to watch. A woman pulled out her phone and started recording from about 20 feet away. "I am not going to ask you again," Officer Harlan said. "Step away from the vehicle and provide identification." Judge Langford made a decision. She would comply under protest, document everything, and handle it through the proper legal channels. She had been a judge long enough to know that arguing with police in parking lots could be dangerous, especially for African Americans. "Officer, I will comply with your request, but I want to state clearly that this stop lacks reasonable suspicion and violates my Fourth Amendment rights. Now I am going to reach into my purse to get my identification." She moved slowly and deliberately. Her hand stayed visible. She reached into her purse and pulled out her wallet. Inside were her driver's license, her federal judge identification, her court security credentials, and her California state bar card showing she was a licensed attorney. She handed him her driver's license first. Officer Harlan looked at it. Vivian Langford. The address matched the vehicle registration he could see through the windshield. "Is this your car?" he asked. "Yes, and it proves it." Judge Langford lifted the remote and pressed the lock button. The car lights flashed and the locks clicked. She pressed unlock. The lights flashed again and the locks opened. Satisfied? She asked. Officer Harlan should have apologized and left. He had stopped someone who was simply loading her own vehicle with her own belongings. There was no crime, no violation, no reasonable suspicion. But Officer Harlan had a problem. He had started this stop in front of witnesses. He had escalated the confrontation, and backing down now would look like weakness, so he doubled down. You are being belligerent and uncooperative. I am going to need you to wait here while I verify this information. Have you ever been detained by police for doing absolutely nothing wrong? Write yes or no in the comments. Judge Langford felt her anger rising, but she kept it controlled. Officer, I have provided identification. I have demonstrated ownership of the vehicle. There is no legal basis to continue this detention. I am free to go. You do not need to wait while you process my information. On what grounds? On the grounds that I am conducting an investigation. An investigation into what crime? Officer Harlan walked back to his patrol car with her license. Judge Langford stood beside her Mercedes with her hands visible, waiting. She looked at the woman who was recording and gave her a small nod. The nod said, "Keep recording." This matters. Officer Harlan sat in his patrol car, running her license through the system. It came back clean, no warrants, no criminal history, a perfect driving record. The registered owner of the vehicle matched the license. Everything was in order. Officer Harlan should have returned the license, apologized for the confusion, and let Judge Langford go, but now he had a bigger problem. He had made an improper stop and prolonged it beyond any reasonable point. He needed to find something to justify his actions. He stepped out of the patrol car and approached her again. "Ma'am, I am going to need to search your vehicle." Judge Langford's eyes narrowed. "On what basis?" "I have reasonable suspicion that there may be stolen merchandise inside the vehicle." "Based on what?" "I have receipts for everything I bought. The bags are from stores right here in this mall. What specific and articulable facts form your reasonable suspicion?" Officer Harlan was trapped. He had no facts. He had only a vague suspicious person report and his own assumptions. That was not reasonable suspicion. That was not probable cause. That was bias. "Ma'am, you are being uncooperative. That gives me reasonable suspicion." Judge Langford almost laughed. "No, officer, it does not. Asserting my constitutional rights is not evidence of criminal activity. Arizona versus Johnson makes that clear. You cannot use my refusal to consent to a search as justification for reasonable suspicion." Officer Harlan's face flushed. "You are a lawyer. I am a federal judge." The parking lot seemed to fall silent. Even the background noise of traffic and shoppers seemed to fade for a moment. Officer Harlan stared at her. "You are what?" "A federal judge, United States District Court, Southern District of California. I have served for years, and you have just violated my Fourth Amendment rights in such a clearly established way that you will not be able to claim qualified immunity." Officer Harlan's hand moved away from his weapon. His posture changed for the first time since the encounter began. Uncertainty crossed his face. "I need to see that proven." Judge Langford reached into her purse again and pulled out her federal credentials. The official United States Court's identification with her photograph, her name, her title, and the seal of the federal judiciary. Officer Harlan took the credentials and studied them. His hands trembled slightly. "This could be fake," he said, but his voice had lost its authority. "Call the federal courthouse. The main number is public. Ask for Chambers. They will confirm my identity." The woman who was recording called out from 20 feet away. "I have the entire thing recorded." Officer Harlan looked at her, then back at Judge Langford. "Ma'am, I am going to need you to step away from the vehicle." "We have already passed that point, officer," she said calmly. "You have already detained me illegally. You have prolonged the detention beyond any reasonable length. You have requested a search without probable cause, and now you're escalating because you realize you made a mistake. What you should do right now is return my identification, apologize, and call your supervisor." "I do not have to do anything." "Actually you do, because I am not only going to file a complaint, I am going to file a federal lawsuit, and every decision you make in the next 60 seconds will be evidence in that lawsuit." Officer Harlan made the worst decision of the day. Instead of de-escalating, instead of calling a supervisor, instead of admitting the error and trying to minimize the damage, he chose to assert his authority. "Ma'am, turn around and put your hands behind your back." "Why am I under arrest?" "For interfering with a police investigation." "There is no investigation. There is an officer who saw a black woman near an expensive car and jumped to conclusions. But if you are going to arrest me, do it. The recording is running. My credentials are in your hand, and you are about to make the biggest mistake of your career." Do you think the officer should have apologized and left at this point? Let me know down below. Officer Harlan pulled out his handcuffs. Judge Langford turned slowly and placed her hands behind her back. The cold metal clicked around her wrists. The woman who was recording was now on her phone, presumably calling someone. Other shoppers had stopped to watch. A small crowd was forming. "What is happening?" someone asked. "The police are arresting a federal judge for loading groceries into her own car," another person replied. Officer Harlan led Judge Langford to his patrol car. She did not resist. She did not argue. She simply walked with calm dignity, head held high, her expression unreadable. He placed her in the back seat of the patrol car. The plastic seat was hard and uncomfortable. The car smelled of stale coffee and the chemical cleaner they used on the seats. Judge Langford sat perfectly still. Her mind was already working on the legal strategy. What claims to bring, what evidence to preserve, which witnesses to contact. Officer Harlan sat in the front seat and stayed there for a moment. He picked up the radio, then set it down, picked it up again, and set it down again. He knew he had made a mistake, a catastrophic one, but he had committed to the arrest. There was no undoing it now without looking incompetent. He started the car and headed to the station. The drive felt endless in the heavy silence. Neither of them spoke. When they arrived at the station, Officer Harlan led Judge Langford inside. Other officers looked up from their work. They saw a well-dressed black woman in handcuffs and at first thought little of it. Officer Harlan took her to the processing area. An officer named Lena Vargas was assigned to process her. Officer Vargas was a veteran who had seen everything. She began the standard booking procedure. Personal belongings were removed and catalogued. Phone, keys, wallet, jewelry. When Officer Vargas opened the wallet, she immediately saw the federal judge credentials. She looked at the identification card, then at Judge Langford, then at Officer Harlan. "Where did you arrest her?" she asked quietly. "In the La Jolla Mall parking lot." "What was she doing?" "Loading shopping bags into her car." Officer Vargas's expression did not change, but her eyes hardened. "What are the charges?" "Interfering with an investigation." "What investigation?" "Suspicious person report." Officer Vargas held up the federal credentials. She verified them. "I think these might be fake." Officer Vargas had processed thousands of arrests and had seen every kind of fake credential criminals could produce. These were not fake. The holographic seal, the microprinting, the weight and texture, they were genuine federal court credentials. She stepped away from the processing counter and walked straight to the watch commander's office. Lieutenant Raymond Freeman had been with the San Diego Police Department for years. He had handled difficult situations and managed controversial arrests. But when Officer Vargas entered his office holding federal judge credentials, his stomach dropped. "Where is the person these belong to?" he asked. "In the processing area. Officer Harlan brought her in and arrested her for interfering with an investigation." Lieutenant Freeman stood up immediately, walked to the processing area, and looked at Judge Langford sitting quietly in the waiting chair. He looked at the credentials again, stepped into his office, closed the door, and made a phone call. The call went to the on-duty chief of police. The conversation was brief. When Lieutenant Freeman hung up, he looked as if he had aged years. He returned to the processing area. "Judge Langford, I am Lieutenant Freeman. I apologize for this situation." "You will be released immediately." "What charge was I being held on?" Judge Langford asked. "That is being reviewed. I want everything in writing. The initial call report, the body camera footage, the dash camera footage, the booking report, and a written statement from Officer Harlan about probable cause. Everything." Lieutenant Freeman nodded. "We will have digital copies ready for you." "How soon?" "We can have digital copies ready tonight." There was no room for negotiation in Judge Langford's voice. Lieutenant Freeman recognized the tone. He had heard it before in courtrooms, the tone of a judge who had issued a ruling and expected compliance. "I will make sure you have them tonight." The handcuffs were removed from Judge Langford and her belongings were returned. Lieutenant Freeman himself escorted her out of the station, apologizing several more times before she climbed into the Uber she had called. Judge Langford arrived home and sat in her living room for a long moment, processing what had happened. Then she picked up her phone and began making calls. The first call was to the Chief Judge of the Southern District of California. The second call was to her lifelong friend who practiced civil rights law. The third call was to the American Civil Liberties Union. By the next morning, the incident was being discussed at the highest levels of both the federal judiciary and the San Diego Police Department. The chief of police called Judge Langford personally to apologize. She listened courteously and stated that she would file a federal lawsuit. The lawsuit was filed soon after, 24 pages, single-spaced, with references to Supreme Court cases and specific timestamps on the video and body camera recordings. The complaint alleged illegal detention, false arrest, violation of Fourth Amendment rights, violation of equal protection under the 14th Amendment, and racial profiling. It named Officer Harlan individually and the city of San Diego. The city attorney's office reviewed the case. They watched the parking lot security footage. They watched the body camera footage. They read the complaint. Then they called an emergency meeting with the chief of police and the city manager. "This is indefensible," the city attorney said bluntly. "We arrested a federal judge for loading her own car. The video shows it clearly. We have no legal defense. We need to settle." But before settlement negotiations could begin, the story leaked to the media. Local news picked it up first, then national outlets, then legal publications. "Federal judge arrested while shopping" became a headline that spread across the country. The video, recorded by the woman in the parking lot, was posted online. It quickly racked up millions of views. In a short time, it had been seen by tens of millions. The comment sections exploded. People shared their own stories of being profiled. Legal experts dissected every violation Officer Harlan had committed. Civil rights organizations used it as evidence of systemic problems in policing. The San Diego Police Department opened an internal investigation. They assigned their most experienced internal affairs investigator to the case. The investigation was thorough. They interviewed Officer Harlan multiple times and reviewed every second of available footage. They examined the suspicious person call that had started it all. The findings were damning. The suspicious person call had come from a mall security guard who later admitted he thought Judge Langford looked out of place near expensive cars. When pressed on what that meant, he could not articulate any specific suspicious behavior, only a feeling. Officer Harlan responded to that vague call and immediately focused on Judge Langford based on her race. He had detained her without reasonable suspicion. He had prolonged the detention beyond any reasonable length. He had requested a search without probable cause. He had arrested her for asserting her constitutional rights. Every action he took violated department policy and constitutional law. The investigation also uncovered patterns in Officer Harlan's history. In the years before the incident, he had conducted stops involving black motorists at a rate far higher than the department average. His citations of black motorists showed similar disparities. His arrest rates revealed comparable imbalances. The pattern had existed for years. No one had examined the data. No one had connected the dots. Officer Derek Harlan was fired after the incident. The termination letter cited multiple violations: illegal detention, false arrest, racial profiling, violation of department policy, and conduct unbecoming an officer. Officer Harlan tried to appeal. His union representative reviewed the footage and told him what everyone else was saying. "You are finished. The video is too clear. The victim is too credible. The violations are too obvious." Officer Harlan withdrew his appeal, but his firing was only the beginning of the consequences. The Department of Justice Civil Rights Division launched an inquiry into the San Diego Police Department's stop and search practices. Its goal was to determine whether the bias shown by Officer Harlan was an isolated incident or reflected broader problems. The inquiry examined data from multiple years, reviewed thousands of police reports, and interviewed dozens of officers and community members. Its conclusions were presented in a lengthy document. It revealed that African American residents were detained at a significantly higher rate than white residents, even after adjusting for crime rates and population density. African American drivers were subjected to vehicle searches at 3 times the rate, despite being less likely to be found with contraband. As a result, the San Diego Police Department entered into a consent decree with the Department of Justice. The reforms implemented were comprehensive, including mandatory implicit bias training for all police personnel, an early warning system for officers with patterns of problematic behavior, the creation of a civilian oversight board with real authority, regular audits of stop data broken down by race, the requirement of body cameras for all uniformed officers, and a period of federal oversight. The lawsuit filed by Judge Langford was resolved several months after the incident. Although the settlement amount was never made public, sources close to the negotiations indicated it reached $75,000. Judge Langford donated the entire sum to civil rights organizations dedicated to police reform. "I do not need the money," she told the press in her only public statement about the event. "I need the system to change. I need other people who do not have my resources and position to be protected from what happened to me." The parking lot security footage became required viewing in police academies throughout California, used in constitutional law classes. Civil rights organizations employed it in community education sessions. A detention in a parking lot resulted in the end of a professional career, a settlement of $75,000, a federal consent decree, and systemic reforms that changed the entire operation of a police department. Officer Derek Harlan never worked in law enforcement again. His justified termination made him ineligible for other agencies. He tried private security but could not hold a stable job. Eventually, he left California altogether. He gave one interview to a local media outlet, claiming he had followed his training and that the judge had been uncooperative. The interviewer asked if he had seen the footage. Officer Harlan said yes. When asked about the specific suspicious behavior Judge Langford had engaged in, he could offer no answer. Judge Vivian Langford returned to her judicial position, continuing to preside over cases, including several involving police misconduct. Her colleagues noted that the experience made her even more attuned to civil rights issues in her courtroom. In private conversations with other judges, Judge Langford has expressed that what happened to her was not unique, merely documented. She has stated that thousands of African Americans experience similar treatment every day, but lack federal credentials, legal knowledge, and resources to defend themselves. For that reason, she advocated for the public release of the footage and donated the settlement money so the incident could serve as a teaching tool. It allows the public to see how racial profiling manifests and lets officers learn that assumptions do not constitute evidence and that prejudice does not equal reasonable suspicion. The security camera recording remains available online for anyone to watch. You can see a federal judge calmly asserting her rights while being detained simply for shopping while black. You can witness the moment Officer Harlan realizes what he has done and see what accountability looks like when the system actually works. What is your biggest takeaway from this story? Share it in the comments below, and if this has opened your eyes to the reality of racial profiling, make sure you subscribe, because we bring you stories that need to be heard. This story matters because Judge Vivian Langford had every advantage: legal knowledge, credentials, position, and authority. Yet she was still handcuffed in a parking lot for loading bags into her own car. Think about all the people who do not have those advantages. The ones who are stopped and questioned based on assumptions, arrested for exercising their rights, and who lack the knowledge or resources to fight back. Judge Langford's story shows that even with every advantage, prejudice can still strike, but it also shows that accountability is possible, that the system can work, and that violations can have consequences. Not every illegal detention ends in justice, and not every case of racial profiling results in firing and reform, but this one did, and that is significant. Thank you for staying with this story until the end. If it has made you reflect on police accountability and racial profiling, share it with someone who needs to see it. Hit subscribe if you have not already. We will continue bringing you stories that matter. Leave a comment. Do you think $75,000 was enough? What would real accountability look like? See you in the next video.